Morning, everyone. Our first case this morning is State of North Carolina X-Ray Utilities Commission et al. Versus Carolina Industrial Group for fair utility rates, second et al. And we will hear from the appellant.
Good morning, and may it please the court. I am Derek Mertz. With me is my colleague Terrell Moore, and we represent the Attorney General in this matter. Appellants in these consolidated cases intend to split the time allotted, 15 minutes for the Attorney General's office, 10 minutes for CUCA, and 15 minutes for SIGFR. To the extent any of my time remains, I would like to reserve 3 minutes for rebuttal. In 4 arguments, the Attorney General challenges 3 of the Commission's decisions. The first 2 arguments involve the Commission's giving Duke Carolinas a 10.1% rate of return on common equity, or ROE, where Duke Progress received an ROE 30 basis points lower. The third and fourth arguments involve the Commission's giving certain rate-making treatment outside its statutory authority by first allowing Duke Carolinas a return on its vegetation management expenses, and by next allowing each company to admit from the decoupling calculation permitted by statute an estimate of its EV revenues. Duke throws a stack of papers and numerous red herrings at this court, hoping that it will yield to the deference ordinarily given to the Commission. But let's be very clear. All 4 arguments challenge the Commission's failure to follow the law and its failure to show its work. These are not matters of discretion, and each of these decisions should be reversed. ROE is meant to reflect the utility's investment risk and ordinarily should be equal to those given at the same time in the same part of the country to utilities with similar risks. The Commission is also required to give the lowest possible ROE that is fair to both investors and ratepayers. There is no doubt that these companies have the exact same risk profiles, compete in the same markets, setting rates for the same state and in almost the exact same 3-year period. They presented materially identical evidence and positions in almost every facet of their respective rate cases, with Duke presenting verbatim substantive testimony on ROE in each case, with its ROE expert forming his ultimate recommendations for both cases at the very same time based on the same inputs and methodologies, and with that same expert stating at this hearing that there was no substantive difference between the companies for purposes of ROE. Yet the Commission gave different treatment to what was in essence the very same company, and will in fact become the same company by the end of these rate cases, by the end of 2026 when these rates are to go into effect. And the Commission did so without acknowledgement of its earlier decision or explanation why it was departing from that earlier result.
Why doesn't this court's decision in VEPCO foreclose this argument?
So VEPCO really doesn't apply because that was dealing with the circumstances where they were not inconsistent results. This court decided that the earlier decisions, which were instead of 3 months apart, 3 and 4 years earlier, were neither precedential and were in fact twice decided that the facts and circumstances between the cases were markedly dissimilar. So in essence, what this court determined was, of course, this court reaffirmed the longstanding position that the Commission's rate-making decisions or its decisions are not entitled to stare decisis and binding effect. But that's no different than how the federal courts and this court has treated other state agency action. That's true. Stare decisis does not apply, but that doesn't mean that agencies are not still required to provide consistent results, or where they're departing from those earlier results, give an acknowledgement and explanation why they're choosing not to follow.
It's that second part of your argument that I'm struggling with a bit, and the reason is because this isn't, well, let me ask you if you agree with me that these rate-making decisions, this is not the sort of thing where there's one objectively correct answer. For example, there are sometimes when an agency may need to make a determination, like let's say, was the traffic light red or green? And if the agency on the same facts with the same general parties one time said that the light was green and then in a proceeding not long after said the light was red, you could make some argument that even if there's no sort of estoppel or stare decisis effect to that, there's some arbitrariness to the difference and no explanation of why. But here, this court has said over and over that there is this sort of regulatory discretion that's built in, this subjectiveness of the decision. Do you agree with that?
Well, I agree that in a vacuum, that's true. But if the commission has decided that the most appropriate ROE for these precise circumstances is X, then when it departs from that very same conclusion, it is acting arbitrarily and capriciously. It's already decided what the correct answer is on these same identical facts.
Would you agree that if you were to sort of build a trend line of all the experts and the rates they recommended in the two proceedings, that it wouldn't just be Duke's experts, sort of the trend line for all of the opinions moved up by the time of the second proceeding from the first? Would you agree with that?
I would not. Duke's position in the first proceeding was that it be given, and this court can look to Duke's brief in the progress case stating definitively that it was not changing its position.
Well, I wasn't asking about what Duke's position. I was saying the evidence. If you made a trend line of the average of the witnesses, of the evidence that was in the record, of what the recommendation of the appropriate amount was, if you looked at it, wouldn't it be different in the second proceeding than it would in the first?
I think what you're getting at is that the interveners in the second case adjusted up their ROE recommendations because they took into consideration something that Dr. Morin had already taken into consideration and that was already before the court, that being the rising interest rates or the fact that they changed. But the commission's decision isn't based on any of that intervener testimony. And the commission's not simply supposed to, if the public staff in this case were to recommend a 6 and Duke were to recommend a 10, the commission's not supposed to say, hey, the midpoint of these two recommendations is 8. And that's always been the case. And so if the 6 then goes up to 6.5, it determines an 8.25 is next. It's not supposed to just figure out where the midpoint is. It's supposed to reflect by law, it has to find the lowest reasonable possible ROE for the facts and circumstances.
What I was getting at is the very fact that that evidence exists, though, doesn't that undermine your argument that there's somehow some arbitrariness built into the decision because it simply isn't the same record? And so and in a subjective decision like this, then it would be entirely expected that you might have some difference between the two. So really, we just need to look at the record in that second proceeding and say, is the statutory standard satisfied here? We would be comparing apples and oranges to go back and try to do it based on a record that wasn't the record in this proceeding.
Well, I don't think it's comparing apples and oranges. I think what we're doing is comparing apples and apples. And the point, I think, we agree that the intervener testimony did slightly change, but that testimony wasn't material to the commission's decision. It didn't say in its decision the reason we're adjusting up is because we now credit more the intervener testimony. If it credited that intervener testimony, this wasn't a decision that was a 9.25% ROE in the first case and a 9.35% in the second. What essentially the commission did is that's not material evidence. It would be no different if then, in any of these cases where you're talking about inconsistent results and you're talking about identical facts, there absolutely are different facts that are presented in the two proceedings. And I would point this court to Colorado Interstate Gas versus FERC, where the DC Circuit was addressing the Kansas's treatment and Texas's treatment of similar state tax provisions. And of course those records were different. Fundamentally different in comparison to the records in the case that you have before you. But what the court determined was the important facts, the material facts, were identical. And in this case, this is no different than if you had a traffic stop and an officer said, well, the defendant was wearing a blue shirt in this case, and 6 weeks later, the officer says, well, the defendant was wearing a red shirt. This court would say that's not a material fact to whether or not there was reasonable suspicion. It's not a material fact to that decision where you are, in fact, addressing a multitude of facts and factors. Of course, ROE addresses a number of concerns and sort of weighs and balances, but it's no different than any other independent decision. And having made it in that first case, and those facts and circumstances appearing to be identical and on point, the commission was at a minimum required to acknowledge the DEP result and explain why, in this case, it wasn't also giving the 9.8%. So let me read from the commission's own words, and I would direct this court to record page 3617. It is reasonable and equitable to apply the same approach in this case as was approved in the DEP rate case order. It would not be beneficial to apply inconsistent principles as between DEP and DEC when there is no evidence supporting such a decision. It's not enough that were the commission to look at these facts and circumstances in a vacuum, it might well have decided that a 10.1% was appropriate. You know, that's the rational basis test. But the standard of review for this, before this court and for the commission, is a higher standard, and that's the arbitrariness and capricious test. And under all administrative law, when there are identical facts and circumstances, the agency making a departure from those is supposed to acknowledge and explain why.
Counsel, I'm sorry. When there are identical facts and circumstances, did I mishear you when you said previously, when I think you said previously, there were different facts in the proceedings?
There are different, of course there's different facts, but they're not different material facts. What is important is that the material facts are identical to and the only evidence upon which the commission's result could rest has to be Dr. Morin's testimony. No other intervener's testimony supports a 9.8, let alone a 10.1. Not even their ranges go that high, and to the 10.1, and they don't incorporate that. So there's no basis. It's not simply a, well, one side puts up, 50, the other puts up 100, and we split the baby. That's not what the commission's, supposed to do in these cases. It's supposed to reach the lowest possible reasonable result that balances the interests of investors and ratepayers. And what you're basically doing, this is a stand-in, what ROE is a stand-in is to weigh the risk profile of those utilities. And Duke Progress and Duke Carolinas are precisely the same. They have identical risks and circumstances that should go into that decision.
I guess I think I'm understanding now more of why you were pushing back against my question, but I'm still struggling because it seems like then the premise of your argument is that the commission would be required to just accept a recommendation from some expert who's saying, this is what I'm calculating as I've calculated 10%, and then you might have another expert that I calculated 6, and the options are, given that testimony, 6 or 10. And I was starting from the position that you can parse out why those experts arrived at those numbers and choose something else, and that would still be soundly within the commission's power under the statute. And that's what it seemed to be happening here, is that it was then looking at things that had changed in the record of the second proceeding, where in general you were looking at just recommendations of higher rate than what you were before and saying, okay, we're going to choose a new number this time. That's not what anybody specifically recommended, but it's our view of the whole record, what the appropriate rate is. But
that is sort of the commission acting in a vacuum. I don't know how it can disregard that it just looked at these. I think we would agree that if this court determines that these are not materially identical facts, or that these are not inconsistent results, then the only standard of review is rational basis review. Is there evidence to support the result? But that's not what essentially 70 years of administrative law have held. This isn't something that is this isn't a new concept. There are very fundamental reasons for why this is the law. You're supposed to provide guidance and stability for those who are governed to ensure that they're dealing impartially. The commission owes an explanation when it changes course it not only owes an explanation to
But
the
I guess let me make
legislature-
sure because I want to make sure that what I thought the law is isn't a change in 70 years of precedent. But so is your position, if the commission is hearing from experts, and one expert says, I think the rate needs to be 10%, here's my methodology, here's why I think, here's how I'm arriving at that number. And then the commission also receives a recommendation that's at 6%, and it finds some information that it views as persuasive in the methodology of the expert that arrives at 6%, but finds most of what's in the 10% persuasive, and considering those factors arrives at a number that no expert recommended, let's say 7.5. That is consistent with our precedent to say that the commission, that's within their sound regulatory judgment there to hear that evidence and arrive at that number, right? Would you agree with that? Or do you think you have to somehow choose
No,
one of the
no. You
recommendations?
can obviously weigh between the experts, but the difference between that scenario and this is they just did that, and nothing changed. Nothing changed about the risk profiles of these utilities or the time for which we're actually lending this money. This is supposed to allow the utility to gain market capital at reasonable rates, both for its investors and its ratepayers. But this is the same, it's 36 of the same 39 months, forward-looking months. It's the same test period. It's the same exact risks that are being presented by the utility. I mean, if you look just side by side with what they say, it's copy and paste. And so I don't know how this court could arrive at the conclusion. If this isn't identical facts and circumstances, then there'll never be a case where an agency is faced with the same identical facts and circumstances.
So help me understand on page 17 of your brief, if I understand correctly, you're discussing ROE there. The North Carolina Justice Center arrives at 6.15 for DEC and 6% for DEP. Is that unreasonable?
So the differences in the intervener's testimony, and I would like to note that I'm well within my fellow appellee's time, and I'm happy to, obviously I'll continue to answer questions of this court. But the differences between the intervener's evidence was simply that their testimony didn't account for rising interest rates at the same time that Duke's expert did. But Duke's expert did, and he put that before the commission, and then that was all known. By the time of the hearing in progress, that was known. But they prepared their testimony earlier at a time that they were using essentially stale evidence when they presented those earlier numbers. But the commission was well aware of that. And again, the commission didn't find a 6% and a 6.15% in the proceedings. It didn't rely, and it didn't say the difference and the reason why we're giving a different result in the Carolinas case is because of the intervener's testimony.
Is the difference in what the Justice Center discussed or came to on the ROE, is that unreasonable?
Is it unreasonable?
Is the differential on the ROE that the Justice Center came to, is that unreasonable?
So the commission itself entirely discounted
No,
the Justice Center's evidence. They actually called it out as not being reliable in both cases. But in terms of, the question for this court is not, is that an unreasonable result? If that's the question this court determines is before it, then there's evidence to support essentially any result between 9 or even 6 and 10.4. The critical difference between these cases is that 9.8% was already determined to be the lowest reasonable possible ROE for these circumstances. The law requires that the commission in these cases find that result. And so by departing from 9.8, it hasn't given a reason why that's no longer the lowest possible reasonable.
Well, the public staff also came to 9.35 for DEC, according to your brief, and 9.25 for DEP. Is that an unreasonable differential?
Again, the issue is not whether the result that the various experts presented to the commission were reasonable. The question is whether the commission's result was arbitrary and capricious, and it was. I would defer to the remaining appellants since I'm well within their time. We would ask that on the basis of the arguments presented in the Attorney General's briefs, that this court reverse and vacate the Commission's decisions both on ROE, hazard tree removal, and EV revenues in the Duke Carolinas case, and its decision for EV revenues in the Progress case.
May it please the court. My name is Marcus Trafin, and I am presenting argument on behalf of CUCA. Been allocated 10 minutes. Would like to extend this time remaining to reserve 2 minutes for rebuttal. CUCA brings essentially 3 issues on appeal from the DEC rate case. First, approval of ineligible capital spending projects in the multi-year plan. Second, failure to ensure that interclass subsidies have been eliminated. In 3, the return on equity that you've just been discussing. If I may, I'd like to start to address an argument that is unique to CUCA. There is some overlap in our arguments among the appellants, but this aspect is unique to CUCA regarding the inclusion of ineligible costs in the multi-year rate plan. We share an argument that set out in the briefing with the Attorney General that the Commission's approval of hazard tree removal expenses in the multi-year rate plan was legal error because removal of trees will not result in property which is placed into service as required by statute. On this issue, Duke has not contested that the Commission requires it to follow FERC accounting rules. It's not contested that the FERC guidance treats hazard tree removal as expenses, not capital investment, and it is not contended that the Commission has ever approved a deviation from this policy. But there's a broader issue that we've raised in our brief beginning at page 28. Duke sought to include, and the Commission permitted, a number of what we characterize as general spending programs in the multi-year rate plan. These are programs where Duke has a budget based on what it might spend for a collection of related tasks, but it doesn't know precisely where or when or if it will do the work. These are spending programs. Now, obviously, Duke has a lot of those, but they aren't capital spending projects as required by law. Now, I think this is most evident if you contrast the language used in the statute at issue here with an existing statute in the water and sewer context, also permitting a multi-year plan for water and sewer utilities. In the water and sewer context, the utility is permitted to recover reasonably known and measurable capital investments and anticipated and prudent expenses. This is clearly a very broad authorization for recovery of both capital investments and expenses. By contrast, the statute here, 62-133.16, only permits Duke to recover capital investments of a very specific nature. Those are investments for, quote, discrete and identifiable capital spending projects to be placed in service in the applicable rate year. All of that language is new language. It does not exist in the pre-existing water sewer multi-year statute. Clearly, this is intentional on the General Assembly's part, and its descriptive and restrictive language was attempting to restrict the type of capital investments which Duke would be permitted to recover. Under a plain reading of the words of the statute, only investments in specific and identifiable projects which can be placed in rate base are eligible for recovery. Duke's not been able to offer a coherent reading of the statute which gives meaning and effect to all the words used. Under Duke's definition, the General Assembly, under their interpretation, the General Assembly would have just used the water and sewer statute instead of doing what it did here. We raised this issue in our briefing and at the hearing, but the Commission didn't acknowledge in its order our arguments or the Attorney General's arguments. It didn't explain how the challenge projects met the statutory criteria. It offered no interpretation of the disputed language. The silence is deafening, given this is a new statute, new language, importance to ratepayers, and a disputed interpretation. This is error. The Commission is required under GS 62-79A to make material findings on all material issues. I would point the court to the Conservation Council and the Cooper 1 cases. Under this precedent, the decision must be reversed on this grounds. If I could turn to the return on equity argument, I don't want to rehash the discussion that you've just had with Mr. Mertz. We do agree with those arguments, and I would try to make one point clear here is our argument on the relevance of the DEP decision isn't about just blindly following a recent decision. That the purpose of ROE, and I think Mr. Mertz indicated this, is not to engage in a mathematical exercise, which seems to be what happened here. If you go through the order, it turned into a math problem. I don't think any of the expert witnesses contend that it's capable, that determination is capable of mathematical precision. But the guideposts are two: to ensure a fair return for shareholders and keep the returns, keep the rates as low as possible for ratepayers. On the first point, the Commission had just adopted a 4 months before, adopted 9.8% for DEP, and there was evidence in this case that the market responded positively to this decision. There's no better evidence of a credit positive decision than how the market is responding in real time, which is what they had before it. And so armed with that knowledge, all it's left to do is to keep rates as low as possible for the consumers. I'd like to highlight another aspect of the Commission's determination, which further illustrates, kind of builds on the point I was just making about the mathematical exercise, but it's distinct basis for holding that the decision is arbitrary and capricious. We discussed in our brief at page 42 how the Commission engaged in a mathematical manipulation of interveners' data in a way which impacted the ultimate ROE determination. The Commission said that it held this, that it was giving substantial weight to CUCA's witnesses' evidence of ROE on a particular methodology, CAP M. But on the next page, it averaged that data with the public staff's evidence. This averaging in the context where they were trying to take the low, create a range, a low range and a high range, it had the effect of artificially increasing the low end of the range, which had a material impact on the ultimate analysis, because in the end, the Commission reduced this to a mathematical exercise. The Commission never explained, there's no logic or policy basis for this averaging approach. They didn't explain why they manipulated the data in that fashion. We believe that this is evidence by itself of arbitrary and capricious rulemaking and is independent grounds for reversing the decision. I see I'm into my rebuttal time. I would reserve my time for rebuttal, and with respect to the interclass subsidies argument, we would rest on our briefs on that point. CUCA would respectfully ask that the court reverse the Commission's decision for the reasons set forth in our briefing. Thank you.
Thank you, Mr. Chief Justice, and may it please the court. Chris Edwards on behalf of the SIGFA appellants. Probably won't have any time for rebuttal, but I'd like to reserve 2 minutes if I do. We raised 3 issues in our brief. I'm going to take them out of order. I'd like to start with the subsidy reduction issue, move into the transmission cost allocation stipulation, and then finish up with the rejection of the equal percentage fuel methodology. I think there are 2 bases on which the court can vacate the commission's orders on the subsidy reduction. The first is Duke's failure to meet its burden of proof. Justice Dietz, your colloquy with Mr. Mertz is kind of instructive about what I think the problem with Duke's evidence in that regard is. If you look both in Carolinas and in Progress, Mr. Beveridge and Ms. Reed, the witnesses respectively, put forth sort of the same boilerplate discussion about why they think a 10% reduction will be helpful, while how it will eventually achieve, while it be fair, equitable, better align rates with cost causation. That's simply not the standard. There's nothing else in the record from which the commission could have determined that a further subsidy reduction would not have been practicable. What we know based on the evidence in the record is the commission thought a 10% return was practicable and that a 25% return was not. But there's no analysis, there's no evidence, so that the court can understand why 10% is the greatest extent practicable, which is what 133.16b calls for. Even if the court were to disagree with me on that issue, I think there's another issue in the way that the commission treated the evidence and the way it explained its conclusion. And so whether you want to call this arbitrary and capricious or an error of law, I don't know that it matters much, but I think it might slot into both of those buckets. So first of all, the statute requires subsidy reduction by the end of the multi-year rate plan period. And so that's at the end of the 3-year period that was approved in this proceeding. When we look at the subsidies the commission approved, they're not actually getting smaller over time. The evidence in the record, and I think that this is at, in the Carolinas case, is at DocX 17720 through 23, shows that over time, by the end of the multi-year rate plan period, general service customers are subsidizing residential ratepayers. The spread there is to the tune of $343 million. In the OPT, which is where Sigford 3's customers fall, that's to the tune of more than $370 million. And then in the Progress case, the overall subsidy by the end of the multi-year rate plan, large general service, so Sigford 2's customers, they are subsidizing residential ratepayers to a cumulative total of $500 million. And so those subsidies are actually either stagnating or getting larger over time. So for example, in the Carolinas case, general service customers, in rate year 1, their subsidy is about $30 million. By rate year 2, it's $67 million. And by rate year 3, it's $63 million. Now, I'm not asking the court to reweigh that evidence. It is what it is. The problem there, though, is that the commission says that this evidence, these subsidies, help move toward rate parity. It never discusses that last clause of subsection B, which is, what does this do by the end of the 36-month multi-year rate plan period? How does this affect rates over time? And so without that analysis, missing the finding may be a violation of the commission's duty to make statutory duty to make findings to support its conclusions, but certainly approving these subsidy reductions without at least hinting at the fact that maybe the percentage is getting smaller, maybe the rate of return for each class is getting smaller, but in terms of absolute dollar amounts, they're going up. And when you have to adhere to the cost causation principle, when you have to look at who is actually creating the cost the utility is incurring, a subsidy that gets larger in absolute terms is deviating from that principle. I mentioned where this was in the Duke Carolinas documentary exhibits. The subsidies are in the Progress DocX at 13-146 through 49. And that's the evidence that Duke's own experts submitted, showing the subsidies getting bigger in rate year 0, 1, 2, and 3. Turning to the transmission cost allocation stipulation, we think that that is plainly unlawful. It's intended to achieve a policy goal that the rate-making statute, the historical rate-making statute, 62-133, does not permit. The statute calls for the rates to be fair to the utility and its customers. Carolinas is actually now paying or subsidizing customers for progress. I understand my friends on the other side are going to say, no, this is just a correction. It is a subsidy because what's happening is these rates are set by FERC. Carolina's progress and their counterpart in Florida, they share energy under this FERC-approved joint dispatch agreement, which sets the cost at which they share energy. And so Carolinas is not actually paying anything for the energy under the JDA, or if it is, it's some very small amount. And so that's not an actual cost. And all of the cases that have been cited to this court about the proper interpretation of 62-133 relate to actual cost incurred, and not some hypothetical cost that would involve some sort of rebalancing. I think the issue is further compounded by this court's Thornburg decision, which we cited, in our memo of supplemental authorities. In that case, the court says that, the realigning benefits that are approved by the Federal Energy Regulatory Commission, that's not a power the Utility Commission has, because the Supremacy Clause and the filed rate doctrine, which is explained a little more in depth in the Nantahala Power and Light against Thornburg U.S. Supreme Court case that's cited in this court's Thornburg decision, the filed rate doctrine enforces the Supremacy Clause. And so what the public staff, Duke, and the commission have agreed to do, what the commission's determined to do, is run an end around on the filed rate doctrine and effectively achieve an outcome that is prohibited under the Supremacy Clause because it deviates from the FERC filed rates by imposing some additional cost. I don't know whether or not this is absolutely unlawful. I think that there are other mechanisms that the commission could have at least attempted, such as a roll-in method where you disregard the corporate structure of the two entities and treat their generation and transmission facilities as one. I think that might still run into problems under the filed rate doctrine to the extent it deviates from the JDA, but at least that's a more honest attempt at what the commission was attempting to do than moving the rates based on some principle of fairness that's untethered from the statutory language and runs headlong into the filed rate doctrine. Finally, I would like to touch on the fuel cost allocation issue. The commission rejected the equal percentage methodology in the name of the cost causation principle. And it did so by crediting public staff witness Jay Lucas's testimony. Mr. Lucas bases his testimony on the PBR statute, the new PBR statute 62-133.16. As we've explained in our brief, we don't believe that outcome is permissible. I think the PBR statute says that it is supposed to operate independently that riders are supposed to operate independently of the alternative rate-making mechanisms. And so here you've got the commission dealing with future-looking fuel cost, a future fuel rider where it is dependent upon the mechanisms in 62-133.16. And that's impermissible under the text of that statute. But even if that weren't the case, and even if the court disagrees with us on that issue, I think there is a larger problem. The commission discusses the need to adhere to the cost causation principle, and it is sort of ignoring the effect that the subsidies we were discussing earlier have on rates. The base rates already have a subsidy in favor of residential ratepayers baked in. There's a tremendous subsidy baked into base rates. The equal percentage fuel methodology, to the extent it creates a cross subsidy or distorts rates, if you accept, and which the commission did that testimony, if the commission is looking at rates kind of globally, that cross subsidy then eats into the subsidy the residential ratepayers are receiving, and on a global scale results in rates that are closer to the cost of service. And so the commission's decision to reject the equal percentage methodology, we think is both an error of law under its interpretation of 133.16, but also arbitrary and capricious because the commission says it's adhering to the cost causation principle without actually doing so. And so for those reasons, we'd ask the court to vacate both orders. Thank you.
Thank you, counsel. We'll hear from the appellee.
Thank you, Chief Justice Newby, and may it please the court. Kiran Mehta appearing for Duke Energy Carolinas and Duke Energy Progress. In these appeals, the Utility Commission correctly followed and implemented the law, including the new performance-based regulation statute, which itself is part of a new law, Session Law 2021-165, commonly known as HB 951. And its rate orders here under review are fully supported by substantial evidence. Appellants...
If I might go ahead and just interrupt you at this point so I can go ahead and get my question before you. There's been an awful lot of discussion about the difference between the ROE between the Carolinas, for Carolinas organization and then Progress. And your friends on the other side say that it's arbitrary and capricious. Well, in the interest of transparency of government, and also in the interest of my being able or our being able to actually determine whether it's arbitrary or capricious, we're accustomed to seeing findings of fact from organizations like the Industrial Commission or the ALJ that are more specific to why in just a 4-month period there's this discrepancy. I understand there's a formulaic way that this was done by the Utilities Commission, but I, having reviewed all these documents, I can't find in the order itself where the Industrial Commission actually found a fact that states what that difference is. And I know that there were arguments in the briefs and evidence presented at trial, or excuse me, at the hearings, but that's not what we're accustomed to. We're accustomed to seeing an actual finding of fact that might explain that differential. Can you help me with that? Can you point me to somewhere in the actual order from the Utilities Commission that might help me with that?
Sure, and I don't know that there's something specific in the DEC order itself that deals with that precise question. But it is interesting to me that the Attorney General and CUCA come in here and tell you that that the difference between a 9.8 in DEP and a 10.1 in DEC, which is 30 basis points, is arbitrary and capricious. Yet, when they were arguing to the DEC Commission itself, they had a different view of what the ROE for DEC should be, and it was more than 30% lower, or 30 basis points lower than the what they had told what the DEP Commission had just decided. So they're sort of talking out of both sides of their mouth there. And I think the reason for it goes back to Justice Dietz's question. The reason that what the Commission did is perfectly appropriate, because the evidence in both cases is different. The evidence in the DEP lineup of experts had their views on what the appropriate ROE should be. The lineup of experts, and some of them are exactly the same experts, in the DEC case were every single one of them is higher. And there's a reason for that.
Justice Barron's question to be, if in order for us to engage in meaningful appellate review, can we, under the standard that we've created for these Utilities Commission cases, do what I've been trying to do myself, looking at the record, which is piece together some reasoning that the Commission used in their sound regulatory judgment? Or does the Commission need to tell us specifically what that reasoning was so that we can judge whether that was part of their sound regulatory?
Well, both the VEPCO case, which was alluded to earlier, and the Duke Power case, which we cite in our brief, say essentially that as long as there is some explanation for the result, it doesn't have to be neat and tidy like you might otherwise want. That's the teaching of both cases. In this case, it is very clear from the explanations given in both orders why the DEC decision came out the way it did. Because the DEC commission majority was the DEP commission minority, and the DEP commission minority severely criticized the 9.8 ROE award that commission provided. And it said, it's too low, it doesn't meet our standards. Everybody, there are competing utilities that are already above 10%, and they repeated those things in their reflection of why 10.1% was the appropriate ROE to come to in the DEC case.
But isn't it right that the commission didn't cite that change in who's in the minority and the majority as the justification for the difference?
They certainly did not, nor do they need to.
And isn't the question that we have to ask whether or not, I understand that there were different numbers, different recommended numbers that came out, but isn't the real question whether the facts on which those numbers were based could possibly be different?
Well, they are different. The facts are different because the numbers are different because the underlying economic conditions between the time frames in which the two cases are decided is different.
Very small difference in the time frame.
Yes, but also a very small difference in the adjustment of the numbers, and all of the experts made that very small difference in the adjustment of their numbers.
But if I might,
Well, if I can just follow
no, that's fine. I just wanted to interject that it might be a small number, the percentage, but it is multi-millions of dollars to ratepayers.
No, thank you. Yeah. So my question would be, as I understand the record, and I may not have this right, but if what you're talking about is the increase in interest rates and changed economic conditions that would justify the higher return on equity, the commission's award was 30 basis points higher. And as I understand the witnesses, each of them, even Duke's witnesses, only recommended an increase between 10 and 20 points higher.
Duke's was about 20. The others were in the 10 to 15 range. I don't think anybody other than Duke was in the 20 basis point range.
So,
but again, if you think about what the DEC majority said in progress, they said it should be 10%. So they went up 10 basis points. That's all they went up. Exactly in line with all of, in fact, on the lower end of all of the expert witnesses in the DEC case.
But isn't our question, don't we have to ask whether the evidence support, whether the commission has explained the difference that is, so our standard is, was it arbitrary and capricious? And does the evidence in the record explain the difference?
Well, under VEPCO, under Duke, the Duke Power case that we cite, the commission actually doesn't have to explain, but it did in this context. And the real question that deals with, in terms of ROE, in fact, any factual findings by the commission is, are those findings supported by substantial evidence? The appellants don't even dispute that the 10.1 is supported by substantial evidence, and our brief is full of a recitation of what that evidence was. So I think what you can fairly come to an understanding of what the commission did by looking at what it said, and particularly by looking at what it said, the dissenters said in DEP and what they did in DEC. And it's very clear from that comparison that the DEP dissenters turned DEC majority thought, just like Dr. Morin thought, that 9.8 was too low. And they implemented what they thought was the appropriate amount. They increased it slightly from what they thought the DEP appropriate amount was, but that slight increase is exactly in line with every single expert who testified in the DEP and DEC cases. Does that answer your ROE question, Justice Behringer? I know we got somewhat further afield.
No, I didn't see it further afield at all.
Okay, thank you. But let me go back to the what I was thinking I might do at the beginning of my argument was do a little bit of stage setting, because the PBR statute, the performance-based regulation statute, is new. We describe it at some length in our brief, but let me just give you some general background before getting to the specifics of the appellant's arguments that deal with and attack the result under that statute. Under the statute, and particularly in connection with the multi-year rate plan, which is a required feature of any PBR application, the utility has the ability, with the Commission's approval, to set rates based upon approved capital projects that will come online in the future during the applicable multi-year rate period. And the way Mr. Trafin described the statute is basically exactly the same as what I just said. And I should note that while this is a new feature of North Carolina law, it is not by any means a new feature of utilities regulation generally, because many of our sister states have statutes with a forward-looking aspect to them in their toolboxes. So in this respect, North Carolina is really catching up to the rest of the nation and what is generally the norm in other states. The forward-looking investment model is in contrast to North Carolina's traditional rate-making construct, where you look at past investments, historical costs, and as a result of that, there is a gap, usually, between when the investment is made, when it goes into service, and when the rates that are designed to recover the cost of that investment are put into place. And that gap is called regulatory lag. And it always occurs in a historical system because there's always that gap. And what it means in practice is that the utility never fully recovers its costs because some of them fall into that gap. Now, in the traditional system, it's designed for very large projects. Think like a huge power plant, single power plant. And the utility has the ability, when it's dealing with something like that, to time a rate case so that that gap is smaller than it otherwise might be. But that's not what's happened in an HB 951 world. And HB 951 passed with a large bipartisan majority of the General Assembly. And it articulated as state policy an energy transition, but also mandated as part of that transition that the transition be accomplished in a manner that, quote, reasonably assures the continuation of safe and reliable electric service, unquote. What this means...
if I might, and you are reading from...
the PBR statute.
From the statute.
Absolutely, the PBR statute itself. I think it's subsection D1. And there's several things in there that the Commission must take into account, and that is one of them. What this means in practice is that as the utilities move away from coal-fired generation to other forms of generation, they absolutely must, under the statute, make significant and frankly unprecedented levels of investment in their now 60-odd-year-old transmission and distribution infrastructure, so as to strengthen the reliability and resiliency of the electric grid. And of course, a safe and reliable and resilient and secure electric grid benefits all customers. And you need only look at what happened in western North Carolina after Hurricane Helene to understand that. Now, transmission and distribution investments during the multi-year rate period are the investments that CUCA attacks in this case. These types of investments are generally at a much smaller scale than that massive power plant that we talked about earlier. And they are completed at myriad times, not all at once. And so because there's not sort of a single point in time when the investment comes into play and is put into service, they're always subject, all investments are subject to regulatory lag, but these are subject to massive amounts of regulatory lag because they can't be timed into a rate case cycle.
Well,
So
I recognize, I understand your argument here, but what is your response to the argument that the Utilities Commission did not address specifically? I think they were referring to the statute D2J, where it says projected cost and related work papers associated with the discrete and identifiable capital spending projects. What is your response to the fact that that wasn't specifically addressed by the order that your friends on the other side are arguing?
well, let's see what they actually said before we accept what our friends on the other side
And that's why I'm asking,
are
sir.
arguing. So if you go to DEC record page 3570, this is relating to distribution, but there's very similar language that relates to transmission. What they said was DEC witness Guyton described the discrete and identifiable capital spending projects associated with DEC's distribution system proposed to be placed in service for each rate year of the MYRP. And his testimony included the reason for, scope of, timing for. Those are the things that the regulation requires. Now, to get underneath this, on pages 135 and 136 of our brief, we reference the exhibits of the transmission and distribution witnesses. And all you have to do is actually look at those exhibits. And I'll give you an example. There's one from the distribution witness, Guyton, that was just referred to. It's Guyton Exhibit 5A, the first page of which is Doc X page 13993. You look at the page, on the top of the page, there are all of the programs, spending programs that Mr. Trafin talked about. Immediately under the top of the page and going on for 5 more pages are projects that roll up into the spending programs. So the first one on the page is something called the Central 240 Substation Line Project. And the page goes on to list each of the specific substations, very specific locations, that are each individual sub-projects within this Central 240 Substation project. And it marks which of the programs are associated with each of those substations. Now, there's another exhibit that follows along from that.
Before you go, because I have most of these exhibits actually marked here in this very voluminous notebook, I want to make sure I'm understanding your argument that based on the information on 3570, page 3570 that you directed us to, that would be the finding of fact. And you are now pointing us to the evidence that supports that finding of fact.
Exactly.
Okay.
Exactly.
I don't need you to review further exhibits.
Well, the other exhibit it's 4, and the page reference is 13978. Takes each of those projects, each of those substations, says when it's going to be put in place, how many dollars are involved, and all of the other things that the commission wanted. So it's kind of a combination of those two. But that's the evidence. That's what shows you that every one of these things is a project that rolls up into a program. And if you look at the CUCA reply brief, they reference a monograph from the, I think it's the Project Management Institute, which I know statutory interpretation is supposed to be the ordinary and normal meaning of the words. I would suggest that the Project Management Institute is maybe a little bit more specialized than the ordinary meaning, but here's how they define a project. A project is a group of related, a program. Here's how they define a program. A program is a group of related projects managed in a coordinated way. And what we just talked about, Justice Berenger, is exactly that. A group of related projects managed in a coordinated way. And if you want to take a look at the ordinary meaning of project, you can go to the dictionary. Here's New Oxford American, individual or collective enterprise that is carefully planned and designed to achieve a particular aim. Dictionary.com, if you want to just get it out of the internet. Something devised or planned, a large or major undertaking, especially one involving considerable money. These are quintessentially projects. Now, among the projects are hazard trees. And if you look back at that Guyton Exhibit 5A that we talked about, and you look, there's the last column on the page, all the way to the right, is hazard trees. And you can see which of the projects has a hazard tree associated with it. Now, the Attorney General and CUCA say those are O&M expenses, not capital expenses. But they are actually classified as capital expense in DEP. This is actually DEC, since it's only a DEC issue, but in its capital allocation program. And whether something is capital or not is really an accounting judgment. And I would submit with great humility and respect that the commission is probably in a better position to decide an accounting issue, an accounting judgment issue than this court, although this court may have plenty of expertise in that as well.
But isn't it also a statutory question? I mean, isn't our duty to decide whether or not?
Yes, you have a duty to decide that it is a capital project.
Right.
But the evidence is that it is a capital project.
Well, you're telling us because that's how we put it in our books for accounting purposes, but I guess I'm struggling with why the hazardous tree removal is actually creating property that's used and useful, because I understand that just the trimming you categorize as an operating expense, and the distinction between trimming some limbs and cutting down the tree seems to me to be
it gets a little fine. I will grant you that, Justice Earls. But here's the I mean, if you look at our brief, and I think it's on page about 146, 147 in that range, there's the evidence from the accounting witness, the company's accounting witness, as to why it's a capital. And it's classified as capital because it has a long-term impact. Again, hazard trees are outside the right-of-way. They belong to some neighboring landowner that owns the property that borders the right-of-way. And when you chop it down, it has a long-term impact on the reliability of the system. And that's why it is classified as a capital expense. And it has been classified as a capital expense, according to the testimony in the DEC case, for at least the last 10 years, which means, contrary to what was argued earlier, where there was some suggestion that the commission had never approved this, in every single rate case in the last 10 years, including the DEP rate case that is in front of you today, because this issue was not appealed in the DEP rate case. The company has classified this as a capital expense. The public staff has audited that classification and agreed with it, and the commission has allowed cost recovery of it as
Can I ask you an analogy to see if I'm understanding the theory here? So suppose that an electric utility is going to construct an entirely new power plant on the location of an old power plant that's being taken out of service. And so the cost to do that includes both coming in and demolishing the old power plant and then constructing the new one.
Correct.
The
All
argument
of
would
it
be
is
the
capital.
capital expense of tearing down the old one to build the new one is a capital expense.
That is correct.
And your argument here is that there are some trees and there will be other capital, I assume the power lines and other things that need to go here. In order for them to go here, this other thing needs to be torn down permanently and removed, and we're going to put a power line in its place. Is that essentially, I realize I've simplified it, but
Yeah,
is that the
that is correct. And in addition, once the thing is in place, if the tree is in a position of height or whatever it is to now threaten the integrity of that power line, the removal of that tree is very similar to the removal of the original trees that were in the right-of-way, which everybody admits is an appropriate capital expenditure. And that's the argument there, in a nutshell. And the commission has done this in every single case for the last 10 years, and they did it in the companion case, and nobody has said boo about it. Let me turn to the interclass subsidy issue that Mr. Edwards talked about. And basically, what this argument boils down to is whether a 25% subsidy reduction, which is the one favored by CIGFR, or a 10% subsidy reduction, as recommended by DEP, DEC, and accepted by the commission, and recommended also by the public staff, is the right number. I would suggest to you that this is quintessentially a question of fact, very similar to ROE, where the commission is presented with competing factual testimony, and the commission has to use its judgment to arrive at the appropriate number. And the commission's decision is entirely consistent with the PBR statute. And the CIGFR argument is dependent upon not reading the whole statute, but only one little piece of the statute, which foundationally to statutory interpretation, you don't do that. You read the statute as a whole. The statute as a whole says that in passing upon a PBR application, the commission needs to make sure that interclass subsidization, quote, is minimized to the greatest extent practicable. That's what exact words of the statute. That's in subsection B of the statute. And then in subsection D of the statute, it says that in passing upon a PBR application, this is D1, the commission shall consider whether the PBR application assures that no customer or class of customers is unreasonably harmed. And then in C, will not unreasonably prejudice any class of electric customers and result in sudden, substantial rate increases or rate shock. They read those words out of the statute altogether. You can't do that. And the evidence before the commission was, it gets a little complicated, but to simplify it, as a result of a change in the methodology for cost of service allocations from a single peak in the summer, typically the summer, to 12 peaks each month, every month during the year, which basically means that every municipality that doesn't contribute to the peak in the summer, because basically their costs are street lighting in the middle of the summer, August, when all the air conditioning goes on, by the time the street lights come on, the peak is passed. It's very different when you do 12 different peaks all the way through the year. Every single municipality, therefore, experienced an increase in their rates as a result of that change in the cost of service methodology. And the evidence showed that under a 10% subsidy reduction, there was still an increase over and above whatever they otherwise got. But at a 25% subsidy reduction, the increase was much higher In the DEC case, bordering on 40% higher. And so the evidence then was from the witnesses for the public staff and the company, both DEC and DEP, that as a result of that, 10% was sort of the highest you could go. And the commission's ultimate finding, and I can give you a reference, but there's testimony of Teresa Reed, who is the witness in the DEP case. It's recounted in the DEP record at page 2491, where she says, it says greatest extent or maximum extent practicable, and that's what we did. What the commission ultimately decided then, bottom line, was that the 10% subsidy reduction was, quote, less likely to lead to rate shock than a larger subsidy reduction. Same in DEP as in DEC. And I mean, had they gone with a 25% subsidy reduction, I think we would still be here today. But the appellant would not be CIGFR. The appellant would be the League of Municipalities, saying, what you did was rate shock, and you didn't appropriately take into account rate shock. And I don't want to forecast how that argument would play out, but they would have a point. Let me turn very briefly to the electric vehicle exclusion, because I'm already impinging on Ms. Harrod's time. Here, the issue is, it flows from the policy of the state. The policy of the state is encourage electric vehicle adoption. In a decoupled energy world, which is where we are, there's a disconnect now between sales of electricity and the revenues that that the company can keep as a result of those sales. And this is all explained much more eloquently than I can say in the brief, so I would commend the brief to you. In that world, the decoupled world, additional sales relating to electric vehicle charging are not, the utility doesn't get to keep all of that revenue necessarily. And so there's no longer a natural incentive for the utility to encourage electric vehicle sales. So what the statute does is restore that natural incentive. And it says, in order to do this, we're going to allow the preservation to preserve the electric public utilities incentive to encourage electric vehicle adoption. We're going to extract from the calculation of money that's either flows back to customers or is recovered by the utility through the decoupling mechanism. We're going to extract electric vehicle revenues from that equation. And again, the statutory analysis we put in our brief, essentially the Attorney General adds a word to the statute, adds a word that the General Assembly did not add. And again, you can't do that when you're dealing with a statute. The rate schedules that the company, both companies now have are all, there's no exclusion for electric vehicles from any of them. All of them are permitted to be used by electric vehicle owners. Some of them were designed with electric vehicle owners in mind. You can't just say, I'm going to put a word into the statute that the General Assembly didn't put in. And I'm going to return the rest of the time to Ms. Harrod, unless there are further questions.
May it please the court, Jennifer Harrod, on behalf of the North Carolina Public Staff. It's my pleasure to argue here today that the remaining 3 issues raised by the SIGFR appellants with respect to the Commission's rate case orders should be rejected and those orders should be upheld. That is the transmission cost allocation stipulation, the usage-based method for allocating fuel costs, and the Commission's decision in its discretion to allow late filed testimony from the public staff subject to appropriate due process protections for opposing witnesses. Given the shortness of time, I'm probably only going to have a chance to discuss the transmission cost allocation stipulation, but of course I want to address any questions that are that the court may have. This issue should
Let
not
me
even-
then, I will ask one question
Please,
so I don't
Justice Stevens.
get into your other, but in a bench trial, in a judicial officer who hears evidence that is inadmissible, you don't have to give a curative instruction to yourself as the trial judge. You understand what evidence is and is not admissible. And then on appellate review, if it's clear that the court disregarded that evidence or didn't give it any weight, there's no error in that evidence having been. And I'm wondering, in your view, where the commission stands in sort of the spectrum between like a jury who you have to be very careful not to allow evidence that's improper to be heard and a bench trial in front of a judge.
Yes, I would say that it's definitely the bench trial analogy is accurate, and the general tendency with the commission is to allow virtually all evidence, and as you say, to give it the weight that it's due. You know, we've made a bit of a point of this because, as you see, these cases are very complex. There are literally billions of dollars at stake, and they have to be decided on a very tight time frame. And the commission absolutely needs to fully embody that discretion to control the presentment of evidence before it, and not to be concerned, not to be chilled by the threat of appeal. So let me just briefly say, with respect to the transmission cost allocation stipulation, it should not be before this court. I think the authorities cited in SIGFR's own reply brief, the appeal of Barber, the case they recently commended to this court, ME, definitely show that both the requirement for the notice of appeal to be stated with specificity and the requirement of Rule 10.1, Appellate Rule 10.1, that anything that that is going to be brought up on appeal had been presented first to the deciding to the tribunal. Both of those were not at all followed. In fact, SIGFR's own witnesses in this case recommended something very similar to the transmission cost allocation. They said if there's a concern about fairness between the two utilities, let them pay one another a fair price for their transmission assets. Because they did not develop a factual record in this case at all, there was no evidence, the Commission's orders correctly say, no evidence opposing the transmission cost allocation stipulation. SIGFR has, in its brief, resorted to making statements that are not supported by the factual record. Today, SIGFR's counsel said that Carolinas is now subsidizing DEP. That is not anywhere in the record, and I don't believe that the record could be developed to that extent, but there is nothing in the record to say that. I want to briefly, in case this is troubling to the court, obviously it was very improperly, without leave of court, the federal preemption argument was raised for the first time in the reply brief. If that is something that is of concern to the court, we would ask for the opportunity to file a surreply brief. But I would like to quickly steer the court to looking at FERC Order 888, which was affirmed by the U.S. Supreme Court in New York versus FERC. FERC did not take jurisdiction. It could have, but it did not take jurisdiction over bundled retail rates. So what are bundled retail rates? In North Carolina, as a traditionally regulated state, the energy, the transmission that moves the energy over long distances, and the distribution, that's kind of the last mile for that energy, those are all provided as one service. They're all in a bundled retail rate. Even in the JDA, which is attached to SIGFR's reply brief, Section 5.2 specifically notes that the commission, the North Carolina Utilities Commission, retains that authority over bundled retail rates. Here, what the transmission cost allocation stipulation does is it makes an adjustment strictly for retail rates. It does, in fact, represent actual costs. It represents the actual costs, known and measurable, reasonable and prudent, actual costs to maintain a transmission system. And it does not, contrary to the suggestion of council, impinge on any federal tariff. The joint dispatch agreement is only an agreement for the sale of energy. It is completely silent as to transmission. So that takes us out of the case, the Nantahala cases, where there was a trapped cost, where FERC, after a litigated proceeding, had said this is fair rates, and the North Carolina Utilities Commission said no, we think this is fair rates, and the differential between those two was a trapped cost to that utility. Nothing like that is going on here. There is no trapped cost that DEC is being subjected to. It is a totally separate from the joint dispatch agreement, as the transmission cost allocation stipulation on its face states. If there's no other questions, I will take my seat.
Thank you, counsel. There's 52 seconds of rebuttal time.
I'm going to give it a shot. I have 3 points on rebuttal. First, I want to talk about the failure to explain. Justice Berenger, Justice Earls, you both were kind of keyed in on this in the ROE discussion. I think that's a problem that permeates the commission's entire order. If you look at the findings in both orders, there are no real findings about anything. I mean, there's a discussion of the evidence, but the commission doesn't actually explain what it's doing or why. And to the extent that Duke takes the position that VEPCO permits that, I think your dissent in VEPCO, Justice Berenger, is correct, and that case should be overruled, and the commission should have to explain when it's departing in similar circumstances. Second, Duke is mischaracterizing our argument about subsection B, the PBR statute. It says that subsidies have to be reduced by the end of the multi-year rate plan period. So it's possible to evaluate rate shock year over year, but then look at the subsidy reduction as a whole. And here, a flat subsidy reduction doesn't do anything.
Thank you, counsel.
Thank you. Thank you, Mr. Chief Justice.
Mr. Clark.
All rise.